So friends, remedies for the breach of contract, what we were discussing, there are two remedies. One is rescinding the contract, second is making a suit for the damages, and these damages we are classifying them into ordinary damages and the special damages. And the aforesaid compensation is not to be given for any remote or indirect loss. See, you will be entering into several contracts in future in your life. Try to understand, whenever some person who entered into contract with you makes a failure of performance, you cannot claim for the remote loss that you are going to get because of the failure on the part of the other, is a point. Ordinary damages. The aggrieved party must suffer by breach of contract, and the damages must be proximate consequence of the breach of contract and not the indirect consequence. For an ordinary damages, what we are saying, necessarily one should be able to prove that because of this particular breach, this is the damage which I got, bolke prove karna padega, and that must be so proximate, that is a relatable kind of a situation, and it should not be an indirect loss, is a point. Then special damages. Aggrieved party may claim the damages as follows: such damages which naturally arose in the usual course of things from such a breach. This relates to the ordinary damages arises in the course of things, such damages which the parties knew when they made the contract. For a special damage, what is most important point is the other person should be well informed of the consequences of his failure. Only when you are able to inform the other party about the consequences of his failure, then only you can claim for the special damages. So the aforesaid compensation is not to be given for any remote or indirect loss or damages sustained by the reason of the breach. Exemplary or punitive damages. Punitive damages are kept for the simple reason, we don't want to see non-performance, so we wanted to force the others to make the performance just by keeping the penalty, because a penalty, how it will be disproportionate to the loss that we are going to suffer on account of the failure on the part of the other. There the primary intention in punitive damages is to see that the other person will perform because he feels like performing rather than paying the penalty. So exemplary damages are those which are in the nature of punishment. The court may award these damages in case A. breach of promise to mart, where damages shall be calculated on the basis of mental injury sustained by the aggrieved party, wrongful dishonor of the check by the banker. So breach of promise to marry, breach of promise to marry, where the damage shall be calculated on the basis of the mental injury suffered by the aggrieved party, wrongful dishonor of a check by a banker. Even when I have got the money in the bank, banker said the check got dishonored because of the insufficiency of the funds. Similarly, one agreed to marry the other, and this one has told about this marriage to entire world. Then if the other person says I am not going to marry, what will happen? Definitely there will be a lot of mental injury is a point. That is the reason why Divya, उसमें से क्या तुम सीख लिए? जभी items like writing the exams, marriage, ये सब के बारे में, because these are sensitive, one should be very careful. See, it is out of this subject. Let me tell you a small thing. Who is responsible for your mental sufferings? Who is responsible for your mental sufferings? You yourself is responsible for your mental suffering. How come? Because you yourself is announcing something which is not going to happen. Once you announce something, naturally expectations will arise. So दोस्तों, please do remember, the success in the life depends upon how much you will be able to control the expectations of others in you. That is most important, otherwise you will get lot of mental injuries. So here the point here is penalties will be paid in case if you create any mental injury to anybody. So please don't create any mental injury to anybody by promising them something which you can't do, is the point. So exemplary or punitive or vindictive damages. Exemplary damages are those which are in the nature of punishment. The court may award these damages. The breach of promise to marry, where damages shall be calculated on the basis of the mental injury sustained by the aggrieved party, wrongful dishonor of a check by the banker. Yes, now Divya is saying that you have to pay me the penalty, sir, because every day you are creating some mental damage. So point here is mental damage का ये मतलब नहीं, यदि तुमसे बड़े वाले एज में कुछ एडवाइस दिए तो वो हमको मेंटल इंजुरी कर रहे हैं बोल के वो लोग हमको पेनल्टी देना बोलना सही बात नहीं. मेंटल इंजुरी कैसा होना, मैं प्रॉमिस करना तुमको और वो प्रॉमिस से मैं आई एम नॉट डूइंग विद दैट पर्टिकुलर प्रॉमिस, देन यस, that can create a mental injury, more particularly in a sensitive issues like breach of promise to marry is the point, right? So you should clearly understand the things in their proper sense. Then nominal damages. दोस्तों nominal damages क्या होगा? For technical violations and all, there is no material loss and all, it's only a technical violation, then nominal damages will be paid. Damages for inconvenience and discomfort suffered, liquidated damages and penalty. That is, once we want to terminate, how much is the compensation that we have to pay for our rescinding the contract without performing. That is what the liquidated damage. It is specified in the in the contract itself. Because of the failure on the part of the other, if the contract cannot get completed, then they have to pay for that liquidated damages. Penalty is sum which is disproportionate to the damage likely to result due to breach. In India, there is no distinction between penalty and liquidated damages. The courts in India allow only a reasonable compensation not exceeding the specified sum. But under the English law, liquidated damages are enforceable and not the penalty. So in Indian law, they don't make any distinction between the liquidated damages and penalty. Courts will give only reasonable sums as a compensation as a point. So stipulated for interest. What is that? Is for payment of interest in case of the default. It is not in the nature of penalty if the interest is reasonable. In case if it is a huge sum and all, although you give the nomenclature name as interest, it will amount to the penalty. So for payment of interest in case of default, it is not in the nature of penalty if interest is reasonable. For payment of increased interest from the date of the contract, it is always in the nature of the penalty. If unreasonableness is there, then it amounts to, if it is disproportionate, it amounts to the penalty is a point. Then for payment of increased interest from the date of the default only, then it may or may not be in the nature of the penalty depending upon the terms and circumstances. For the payment of compound interest means definitely it is to be construed as a penalty only. So one point, simple point that should go into the mind of you is that penalty will be disproportionate to the loss, whereas compensation will be generally proportionate to the loss as a point. Then for payment of compound interest on the default at a rate higher than the simple interest, then what you call it as, it is called as penalty. For payment of interest at the rate lower than that of original rate, if interest is paid on the due date, it is also in the nature of a penalty as a point. Forfeiture of security deposit, that is, I am asking you to give some deposit and on your failure I am going to take away your deposit money. Such is called as what? a penalty in case if the deposit is too much and our failure creates the loss to the others only a smaller amount, then since the amount which they have forfeited is disproportionate, it can be called as penalty. But if the other person is kind enough to say that from the deposit I will adjust my loss and give it back to you, then it is only a reasonable compensation. So a clause in the contract which provides for forfeiture of security deposit in the event of failure to perform is in the nature of penalty. In such cases, court may award the reasonable compensation only. Suit for specific performance, this is also another right for the person who got affected by the breach of contract. Specific performance means I am not interested in compensation, I want that you perform. That is, and in that case we will ask for the specific performance. Let us suppose I entered into an agreement with Swapna to make sale of a property in Amirpet. Now she gave me the money and I said I am not interested to transfer this property to you, then she can go to the court and can ask the court to make the specific performance. That is, ask me to do the specific performance. She is not interested in the compensation, which is the difference between the market price and the contracted price. She says I want specific performance. That means necessarily Chakravarti has to transfer the same to me. Suit for injunction. Let us suppose denying Swapna, in the given example I am negotiating with Divya and Maunika. Then she came to know that Divya and Maunika came to Chakravarti and is negotiating for that particular building. She can go and ask the court to pass the injunction order. That is, till such time the case is finalized, Chakravarti cannot make sale of this property to anybody. So that is demanding the court to give a stay order. Injunction means the order of the court which prohibits a person to do a particular act is called as a injunction. Injunction is a very, very important term. Possibility of asking what is injunction is there in the exam. Injunction differs from injection. Okay, here it is injunction. Then we move to the practical problems. First practical problem. This is the second time we are making the revision, giving the opportunity to Divya to listen from here. That point here is X contributes to repair Y's home in a certain manner and receive the payment in advance. X repair the house but not according to the contract. Y incurs 1,000 to make the remedy to the defect. Can Y recover 1,000 from X? Ordinary damages. To the extent of the loss suffered, one can ask the other to give the compensation. Section 73 says what? Y can recover 1,000 from X because he suffered the loss which naturally arose in the usual course of the things from such a breach is a point. So this is what section 73 says. Okay, so now the point of interest here is continuing with this kind of small example I will tell you to make you to feel this. Now somebody was saying that is after passing the CPT, once people come to the IPCC, they will go for different at least 2 to 3 coachings for the same subject. Why? Why they will go for 2 to 3 coachings for the same subject? Because it can happen in different ways. Tuition teacher might not completed the syllabus, or other way around, that student may not completely attend the classes. Of course, in the second situation, student cannot ask the compensation from the teacher, but in the second case, if the teacher don't complete the syllabus, that made them to attend extra coachings with extra people, then this original teacher has to pay the compensation. Here the point which we are driving, friends, that is in case of ordinary damages, one should be able to prove that definitely loss is suffered and the compensation which they are asking is equivalent to the loss which they suffer. I gave a contract to Divya to make the repair for this particular building and she did the repairs, but those repairs are not up to the mark. Again I have to spend 1,000 more rupees to do the repairs. Means originally I gave 20,000 to Divya to make the repair. She did the repairs but not in proper shape. Now I have spent 2 more thousand for the completion, then the 2000 I can very well recover from whom? From Divya is a point. That is what practical question number 1, and the reference is section 73 is a point. Then question number 2, friends. X sells certain merchandise to Y, warranting it to be a particular quality, and Y, in reliance upon this warranty, sells it to Z with a similar warranty. The goods prove to be not according to the warranty. Then Y becomes liable to pay to Z 1000 by way of compensation. Can Y recover 1000 from X? Point here is definitely he can recover, provided he informs to the X right at the beginning that he is going to make sale of these goods to somebody else with a similar warranty. If that is well informed to this particular X, then he can claim for the damages. Y can recover 1000 from X because damages were the direct consequence of the breach of contract as a point. Then friends, question number 4. X contracts to sell and deliver 500 bales of cotton to Y on a fixed day. X knows nothing of Y's mode of conducting business. X breaks his promise, and Y, having no cotton, is obligated to close his mill. Is X responsible to Y? Further, in case if the person don't know the repercussions of his failure, the effects of his failure, then he should not be asked to pay for the loss, because for remote losses the persons cannot be asked to pay the compensation. X is not responsible to Y for the loss caused to Y by a closure of the mill, because it is an indirect consequence of the breach of a contract. 5th, a ship owner contracts with B to convey him from Calcutta to Sydney in a A's ship sailing on the 1st of the January, and B pays to A by way of a deposit 1/2 of the passage money. The ship does not sail on the 1st to the January, and B, after being in consequence detained in Kolkata for some time and thereby put to some expenses, proceeds to Sydney in another vessel, and in consequence arriving too late in Sydney loses a sum of money. Is A liable to pay anything to B? See, A is definitely liable to B for making the breach, but not to the remote losses that the B suffered. So section 73 says what? A is liable to repay B's deposit with interest and expenses which he, that is actually that ship not started on that day. After 3-4 days only it could start. For 3 days he stayed in Calcutta. His stay expenses also need to be paid. And the excess, if any, passage money paid for second ship over that agreed upon for the first, but not the sum of the money which B lost after arriving at the Sydney. Yes, instead of going in this ship, he has gone in another ship, and he has to pay more. Then that more also can be claimed, but not that after reaching Sydney he lost his purse. For that loss also this person only is responsible. Volke compensation nailesate. Question number 6. X contracts with Y to pay rupees 1000 if he fails to pay Y rupees 500 on a given day. X fails to pay rupees 500 on that day. Can Y recover 1000? What is the question? X contracts with Y to pay 1000. If he fails to pay Y rupees 500 on a given date, X fails to pay 500 on that day, can Y recover 1000? Actually, the amount to be paid is 500. If failure comes, then 1000 rupees need to be paid. Bolke a contract hai. So section 74 says what? Y is entitled to recover from X such a compensation not exceeding 1000, because it is a special damage, as the court considered reasonable, because in case of stipulation for the penalty, the aggrieved party is entitled to receive only reasonable compensation not exceeding the sum specified in the contract is a point. So once the case goes to the court will look at the reasonability and it will give the reasonable amount not exceeding the amount specified in the contract as a point. Question number 7, friends. X borrows rupees 1 lakh from Y at 12% per annum, interest payable by 5 half-yearly installments of rupees 20,000 each. State the legal position in each of the following alternative stipulations. In case of the default of payment of any installment, interest rate shall be raised to 15%. In case of default in payment of any installment, interest rate shall be raised to 75% from the date of the default. So, point of interest here is, second situation is a penalty situation, and of course this particular case is given to explain to you which amounts to the compensation and which amounts to the penalty is a point. Third case is, in case default in payment of any installment, interest will be calculated at 12% per annum on a monthly compounding basis, not computing, compounding basis. In case of a default in payment of any installment, interest will be calculated at 15% per annum on monthly compounding basis. These are all very, very important because one of them will be picked up and will be put as a question in your exam. In case of no default, the interest rate shall be 9% per annum. In case of default in payment of any installment, whole sum shall become a due is a point. So, एक एक को हम discuss करेंगे. See, in the cases of A, B and D, Y is entitled to recover from X such compensation as the court considers reasonable because the stipulation is in the nature of the penalty. Whenever there is a penal provision, once the aggrieved party goes to the court, court will look into the matter and award a reasonable sum not exceeding the amount specified in the contract, more particularly when the clause is a penal in nature. So, if it is a penalty clause, then what the court will see the reasonableness and award a reasonable compensation is a point. What are ABD? That is, in case of A, in case of a default in payment of any installment, interest rate shall be raised to 15% per annum. Presently, what is the interest rate? 12%. From 12% to putting it at 15% is considered as penalty. Similarly, interest rate shall be raised to 75%, it is also penalty. D is what? In case of a default and payment of installment, interest shall be calculated at 15% per annum on a monthly compounding basis. These three are the cases wherein we say it is of penalty in nature, so court can grant a reasonable sum not exceeding the amount specified. Whereas in case of C and E, what is C and E first? Case C is what? Case C is, in case of default in payment of installment, interest will be calculated at 12% per annum on a monthly compounding basis. They are not increasing the rate of interest. In the case of E, in case of no default, interest rate shall be 9% per annum. They reduced it. In these situations, it is not a penalty. Y is entitled to recover from X as per stipulation because stipulation is not in the nature of a penalty. Penalty का मतलब क्या है? Rate of interest getting increased or unreasonably too high is a point. In case of case F, what is case F? In case of default in payment of any installment, the whole sum shall be paid. This does not involve any penalty and all, except that what we are saying, the contract may be enforced according to its term because stipulation is not in the nature of a penalty. So, in case of A, B, D, it is penalty, and in case of C and E, since the rate of interest is not changed, it is not a penalty. In case of case F, also it is not a penalty, it is a simply stating that how to discharge of that particular contract. If there is failure on even one single occasion, entire amount is to be paid बोलना एक condition होता, मगर it does not create any penalty is a point. Question number 8. X borrows 100 from Y and gives him a bond for 200 payable by 5 yearly installment of rupees 40. With a stipulation that in the default of payment of any installment, the whole sum shall become due. Discuss the legal position. Y is entitled to recover from X such compensation as the court considers reasonable because stipulation is in the nature of penalty. Where I have borrowed 100 rupees, I gave a bond for 200 rupees. Definitely extra how much it is 100. So the rate of interest is too high. So it is in the nature of a penalty is a point. Question number 9. X lends rupees 10,000 to Y without interest for 1 month with a stipulation that in case of default interest shall be payable. State the legal position if the rate of interest is 2% and 3% per annum. For this what we say, X is entitled to recover from X as per the stipulation, because stipulation is not in the nature of penalty, whereas in case B, X is entitled to recover from Y compensation as the court considered reasonable, because stipulation is in the nature of penalty. So the point which we would like to learn from this particular answer is that in case of the penalty clauses being there in the contracts, once the case moved to the court, in all cases where the penalty clauses are there, will think about a reasonable sum and award that particular reasonable sum, provided the compensation is in the nature of a penalty. If the compensation is simply compensation for the damage suffered by the party, then the other party who suffered need to get the damage if it is only in the nature of compensation. Whereas if it is in the nature of a penalty, then court will intervene and will award a reasonable sum is a point. So what is most important? For one to make the distinction between the liquidated damage and the penalty. In case of liquidated damage, since the other person is suffering, only to the extent proportionate to the suffering, the compensation is prescribed, so that amount need to be paid. Once it is a penalty, then the court will intervene and will decide about the reasonable sum and ask the other person to make the payment of such a reasonable sum is a point, friends. Then I move to the 10th situation. A singer contracts with B, the manager of a theatre, to sing at his theatre for 2 nights in every week during the next 2 months, and engages to pay her rupees 100 for each night's performance. On the 6th night, A willfully absents herself from the theatre and B in consequence resigns the contract. Then what is the point? Up to the 5th performance, whatever that is due need to be paid. For the 6th failure to make the 6th performance, nothing will be paid. Moreover, because of the failure, willful failure on the part of the other person, definitely the theatre person can ask for the compensation to be paid by the by that particular actress. B is entitled to claim the compensation for the damages which he has sustained through non-fulfillment of the contract, because person who rightfully resigns a contract is entitled to the compensation for any damage which he has sustained through the non-fulfillment of the contract. Question number 11. X contracted with Y to write a book in 12 volumes for rupees 1 lakh payable on completion of the whole work. Discuss the legal position in each of the following cases. If after completion and delivery of 6 volumes, Y abandoned the publication, and if after completion and delivery of the 6th volume, X died. See, point here is, in first situation, that the person who failed to complete that particular contract need to compensate the other person, because already he has written 6 volumes and all those 6 volumes are used by the publishers, and later on they abandoned the publication, means definitely the loss will be there to the writer, so it has to be paid. Whereas in case if publisher is going to die, then any further performance cannot be expected. So how the answer got developed? X is entitled to claim the compensation for the work already done on quantum merit basis. This is most important. Earlier also we studied on this particular point of quantum merit when we studied the quasi contracts. Then case B, X legal representatives are not essential to claim the compensation for the work already done by X, because the contract to write book in 12 volumes is an indivisible contract. So point here is, X legal representatives are not entitled to claim the compensation for the work already done by the X, because the contract to write a book in 12 volumes is an indivisible contract. If X dies, that it cannot be completed. Once it is not completed, it is not possible for us to say that contract got performed is a point. So there are divisible contracts and indivisible contracts. Where it is a divisible kind of thing, quantum meritum comes. If it is an indivisible one, then quantum meritum will not come into play is a point. With that, we completed a breach of a contract. And of course, one small addition, 12th also let me tell, X brought a horse with a warranty that it was free from any disease. The horse was suffering from a disease at the time of sale. As a result, not only the horse died but infected the other horses also. Discuss the legal position. Point here is, there is a horse which is suffering with certain disease and that is not being informed to the person who is purchasing, and the diseased horse is purchased and that disease is contracted to the other horses also. Now what is the point? X is entitled to claim not only the loss occasioned by the death of the horse but the entire loss which has occurred as a result of the death. So point here is, a particular horse is suffering from some disease, it is not informed and sold, and after purchasing within 10 days that horse died. So whatever the loss that happened, that need to be compensated is one point, and whatever that disease that got attracted to the other horses, because of that whatever the loss that is suffered also need to be paid off as a point, because here the loss which the person is suffering is clearly visible and so intimate is the point to be well understood. So friends, we completed the topic of the breach of contract with 3 times reading of it. Once we did with the subject, then we did it with important points to be referred before exam, and then with the practical problems. Now we will go ahead with the multiple choice questions in this particular topic. Friends, we will make a beginning with the multiple choice questions in the topic of remedies for the breach of contract. Question number 1. In case of the breach of contract, which of the following remedy is available to the aggrieved party? Yes friends, through multiple choice questions also we are trying to revise the subject once more. So the aggrieved party has got what options with him? He can terminate the contract, which we call it as a rescission. He can ask for the damages. He can also ask for a special performance. So these are the 3 aspects which an aggrieved party may do. So D is the right answer. Then question number 2. A party who is rightfully resigns the contract is also entitled to receive the compensation from the defaulting party. A party rightfully who resigns the contract is also entitled for the damages. Yes, he is also entitled for the damages. See, I entered into a contract with X and X made the failure. I have got a right to terminate the contract. Just because I terminated the contract, iska ye matlab nahi, I can't claim the compensation is a point. Only when others terminate the contract, I will get a right to have the compensation is not the point. Even if I terminate the contract, I can still ask for the compensation from the defaulting party. So A is the right answer, true. 3. A party entitled to resign the contract loses the remedy where he has ratified the contract, third party has acquired the right in good faith, contract is not separable, and rescission is sought out by the party only. So point of interest here is where a party entitled to resign the contract loses his rightful right for asking for the compensation and all. See, we ourselves have ratified the default, then we don't get a right to ask the others to pay the compensation, and third party has acquired the right in it in good faith, then also we don't get our right to resign the contract. Contract is not a separable one. Rescission is a sort of a party only. In all these situations, a party entitled to resign the contract loses that remedy to resign the contract is a point. So let us suppose you asked X to supply the goods every morning at 6 o'clock and he started supplying them at 9 o'clock. Without saying anything, you started taking those goods and after 1 month if he asks for the bill, if you say when I asked you to give me at 6 o'clock you gave at 9 o'clock, so I am rescinding the contract बोल के उन्होंने बोल सकते no. Having allowed, having ratified it, he can't now say I am going to resign the contract. Similarly, I wrote a bill which Swapna accepted that particular bill, and then I am making endorsement to Divya, and Divya in all good faith got this particular bill and asked now Swapna to make the payment. Now Swapna cannot rescind on it because this instrument has gone to the other party in all good faith as a point. And where the contract is not a separable one, in that case also rescission, and rescission is sought by the party only, then he cannot, the party is entitled to rescind the contract, loses his right to rescind the contract as a point. So in all these three situations, party who is entitled, who has got a right to terminate the contract will lose his right to terminate the contract. D is the right answer. Question number 4. Offering the relief by way of a specific performance of the contract is at the discretion of the court, the right of the person, and court must give it, provide in the contract both B and C is a point. See, when we enter into a contract, what are the remedies which we have once the other person makes the breach? What we said in the question number 1, that suit for rescission, suit for damages, suit for specific performance. So we can always ask for a specific performance, but it is again for the court to decide and whether the specific performance need to be granted or not. So on that pretext, we say specific performance will be given at the discretion of the court. A is the right answer. Question number 5. In case of a breach of contract, the aggrieved party may sue for what? Specific performance, for injunction, for damages. So specific performance bole to at any cost that work which is promised need to be done. That is what we call it as specific performance. Injunction means stopping the other person from doing, and damages means that is claiming for the compensation and all. So all these are the rights which are there for the aggrieved party or the affected party is a point. Question number 5, D is the right answer. Then 6, restitution is provided in the Indian Contract Act in which section? In section 64 and 65. Restitution का मतलब क्या है? If I enter into a contract with you and I am completing my part of the promise and you received the benefits, then if you are not going to fulfill your part of the promise, whatever the benefits that you have got from me need to be given back. Such situation we call it as restitution. Restitution is provided in section 64 and 65. C is the right answer. 7. Relief of a specific performance and injunction are provided in which act? The Specific Relief Act 1877 is one act which provides for relief of specific performance and injunction. Under which circumstances relief for specific performance and injunction can be given are specified in the Specific Relief Act 1877. Yes, see, definitely there is a right to the contracting party to ask for specific performance. Once the case goes to the court, court will also see is it that specific performance need to be granted or any relief can be given, or under which circumstances relief can be given for the specific performance, and the injunction is provided in the Specific Relief Act of 1877. Question number 7, A is the right answer. Question number 8, specific performance may be ordered by the court when, if there is no standard for ascertaining the actual damage. Where it is not possible to ascertain the actual damage, then specific performance can be granted. Pecuniary compensation is not adequate. Pecuniary means monetary. Pecuniary means monetary compensation is not adequate. The act is done wholly or partly of a trust. The act is done wholly or partly of a trust. In all these situations, specific performance need to be granted. Just to make you to feel, I am going to give you this particular example. Maybe this is not an exact way of describing it. A is in love with B and B promised to marry A, and then finally A is now saying that I am not going to marry you, but by that time itself B is pregnant. Now in this situation, B can always ask the court to see that A marries her. So many stories are coming in TVs like this, not stories, realities also. Then this is a situation where the court need to ask A to marry the B, because how to ascertain the actual damage that is caused to B? Is it possible? No. Is that the monetary compensation is going to be an adequate relief for this? No. The act is done wholly or partly in trust. Loving is something which happens with a trust on the other person. In that situation, how to just say that take this money and forget him? ऐसा बोल सकते? नहीं बोल सकते. So there are certain situations when court necessarily need to ask for the specific performance. वो क्या चीज होता बोले तो there is no standard for ascertaining the actual damage. Actual damage कितना हुआ बोल के आप ascertain नहीं कर सकते. Pecuniary compensation is not adequate relief, and the act is done wholly or partly in trust. In all these situations, specific performance may be ordered by the court, A or B or C. D is the right answer. 9. Specific performance may not be ordered by the court if contract is not certain contract is of a personal nature, contract involves performance of a continuous duty which court cannot supervise. So in all these situations, court may not grant the specific performance. So contract is not certain, contract is of a personal nature, contract involves performance of a continuous duty which court cannot supervise. In these situations, court will not grant the specific performance. Court will never take extra burden by saying that throughout your life we are there by the side of you to protect your interest. ऐसा situations को generally court will not allow a specific performance. If the act is of a long duration and all, it is not possible for court to supervise whether the other party is going to make the specific performance or not. In all these situations, court will not grant the specific performance. So this is also very important question. Contract is not certain, contract is of personal nature, contract involves performance of a continuous duty which court cannot supervise. In all these situations, court will not grant the specific performance. What do you mean by injunction? Or injunction may be, injunction means stopping. Till such time we decide on this particular case, please stop doing this. Bolna kya hota? Injunction. It is a injunction could be temporary or perpetual, A or B. Right is right option is the injunction orders given by the court could be either temporary or perpetual. Continuous. Question number 11. Quantum merit means what? As much as is earned is a point. Quantum merit means as much as is earned. Of course, on quantum merit we have discussed enough. Nobody should be allowed to get enriched at the cost of the others. So what is due for what has done need to be paid to the other person, and one need to receive for what he has done from the other. That is what the concept of quantum merit we studied. As much as is earned is the meaning of the quantum merit. And question number 12. Principles of damage were laid down in which case? Hadley versus Baxendale. This is a English case. Principles of damage were laid down in Hadley versus Baxendale. A is the right answer. Question number 13. Liquidated damages are predetermined at the time of the contract. About the liquidated damages, and we studied elaborately what we said. Liquidated damages, the damage clause will be clearly written in the contract itself as a point. So it is something which is predetermined at the time of the contract, which we call it as a liquidated damage. 13th question, B is the right answer. 14th question, damages which are given when special circumstances are within the contemplation of the parties at the time of the contract is called as a special damages. So special damages, they are clearly conveyed at the time of entering into the contract itself, under which circumstances special damages need to be paid as a point. C is the right answer. Contemplation of the parties. Contemplation, when they will contemplate, at the time of entering into the contract itself. C is the right answer for question number 14. Question number 15. Penalty associated with the contract is a penalty, a payment of money stipulated as in the terrarium. So the point is, penalty associated with the contract is a payment of money stipulated in the contract as a point. So contract itself will specify on failure how much extra disproportionate to the loss need to be paid, that and all you call it as a penalty. So penalties associated with the contract is a payment of the money stipulated as per the contract as a point. A is the right answer. Question number 16. Sum named as a damage in the contract is a penalty. When you call it as a penalty, if penalty amount is a disproportion or greater to the actual loss which a person has suffered. So C is the right option for question number 16. Question number 17. A claim on quantum merit arises when an agreement is discovered to be void when a contract is a divisible one. Quantum merit comes into play only when it is a divisible contract, and when the agreement is discovered to be a void one. In these situations, quantum merit comes into play. So C is the right answer. The following serve as an exception to the exemplary and vindictive damages. Breach by a promise to marry, dishonor of a check by a banker when he possesses sufficient funds to the credit of the customer. Either A or B, none of the above. See friends, vindictive or punitive damages will come only when the other person do something which is going to affect the reputation or which is going to create the mental injury is a point. So the following serve as an exception to the exemplary or vindictive damage. Exemplary and vindictive damages will come when it is a case of dishonor of a check by the banker when he possesses sufficient funds to the credit of the customer, and breach by promise to marry also will be the case because there also mental injury will be there. So none of the above A and B is a exception. So D is the right answer for question number 18. Earlier when we studied about exemplary and vindictive damages, I explained in detail what is a situation when exemplary and vindictive damages can be given or awarded when it is going to create a mental injury or it will make a damage to the reputation of a person is a point. D is the right answer. Question number 19 friends, a stipulation for increased interest from the date of default. The stipulation, in case if there is an increased interest, means that stipulation is in the nature of a penalty is what we have discussed. 19th question, A is the right answer. Question number 20, quantum merit means what? That is as much as gained, as much as earned, a contract for sale, the fact in itself. The answer is B is the right answer. That is as much as earned is called as a quantum merit. Question number 21. In case of dash, the measure of damages depends upon the shock or sentiment of the promise. C, vindictive damages. In case of vindictive damages, the measure of damage depends upon the shock to the sentiments of the promisee. C is the right answer. Question number 22. Vindictive damages are awarded for wrongful dishonor of a check by the banker in possession of the who is in possession of the adequate funds to the customer for breach of the promise to marry. Either A or B. D is the right answer. Question number 23. Anticipatory breach takes place when party deliberately disables himself performing the promise before the due date, refuses to perform his promise. So before the due date, if the party declares that I am not going to complete my promise, that is called as a anticipatory breach. Either A or B is the right answer. C is the right answer. Question number 24. The damage awarded by way of punishment is called as exemplary, or vindictive damage is called as damage awarded by way of punishment. 24, A is the right answer. Question number 25. The promisee's right of rescission is lost in the following cases. Earlier also we discussed on this particular point, when only a part of the contract is sought to be rescinded and such part is not severable from the rest of the contract, then the promisee's right of rescission is lost. So where a particular contract is for many works and these works are not separable, in that situation the party will lose his right to rescind the contract. Just for failure of a small part, you can't rescind the entire contract where the different acts in the contract are inseparable is a point. A is the right answer. Question number 26. In case of breach of contract, the Indian law awards damages only when that particular loss arises naturally, or which parties know that it is likely to happen when they entered into contract. So when compensation will be awarded, when actually the person suffers the loss, and the point that the person will suffer such a loss will be known to both the parties, then only the Indian law will grant the damages as a point. Question number 27. Dash damages awarded with a view to punish the defendant and not solely with the idea of awarding the compensation is, for punishing the defendant, what the damages that are going to be awarded are vindictive damages as a point, or exemplary damages. C is the right answer. Question number 28. In an anticipatory breach, if the promisee opts to end the contract and treat anticipatory breach as actual breach of the contract, the promisee is excused from performing or further performance of his promise. So question number 28, D is the right answer. That is, what is question number 28? In an anticipatory breach, if the promisee opts to end the contract and treat the anticipatory breach as actual breach of the contract, promisee is excused from performing or further performance of his promise. Promisor, actually it's not promisee, promisor. See, if the promisee ratifies the non-performance, then the promisor is excused from performing or further performing his promise is a point. Question number 29. To claim the remedy under the quantum meruit, the original contract must have been discharged by the parties. Should remain same. Must fully performed. All of the above. Point here is, in case if you want to make any claim on the basis of quantum meruit, the original contract must be performed. That is, let us suppose you asked me to make the dance in your theatre for 12 nights and 6 nights I did, and you closed your theatre, and because of which I cannot perform. So in that situation, definitely you have to pay me the amount for whatever I have, the work which I have done as a point. So B is the right answer for question number 29. Question number 30. In which of the following situations specific performance can be granted? Already we have discussed on this particular point, where money is not a substitute or for alternative. So where there is no exact substitute or alternative to the subject matter of the contract, then it is probable that compensation in the money cannot be got for non-performance. So both A and B, in both these situations, specific performance will be granted by the courts. D is the right answer. Question number 31. In breach of contract, compensation is claimed for the proximate and natural consequences of the breach. Please do remember and keep in your mind, for remote losses which parties suffer, court will not grant the damages. Only for those damages which are proximate and natural consequence of the breach, only the damages can be granted is a point. Question number 31, A is the right option. Question number 32, duty to mitigate the damages on the part of the injured party arises. Duty to mitigate the damages on the part of the injured party arises in case breach at the time fixed for the performance of the contract, in case of anticipatory breach, A or B. See, if you enter into a contract and your non-performance is going to create the loss to the other, you have to make all the efforts to mitigate, reduce the loss. So that and all arises in case of the breach at the time fixed for the performance of the contract, in case of anticipatory breach. So both in case of anticipatory breach and breach which happens at the time when it is fixed, in both these cases you have to mitigate the loss suffered by the damage suffered by the injured parties is a point. That made us to say A or B is the point. Question number 32, D is the right answer. Question number 33, A contracts to sell and deliver 100 kgs of sugar to Y at certain price to be paid on delivery, and X breaks his promise. Y is entitled to receive from X by way of compensation the sum, if any, by which the contract price falls short of the price for which X might have obtained 150 kgs of sugar at the time when the sugar ought to have been delivered. Is it a correct statement? The answer is correct. First, you should understand what is the statement given. First, try to feel the case. That is, A contracts to sell and deliver 100 kgs of sugar to Y. So X is the seller, Y is the purchaser. The item to be sold is the sugar at a certain price to be paid on delivery. A particular price is fixed to be paid on a delivery. X breaks his promise. So X, who need to make a sale, is failing in his promise to make sale. Y is entitled to receive from X by way of compensation the sum, if any, by which contract price falls short of the price for which X might have obtained 150 kgs of sugar at the time when the sugar ought to have been delivered. Yes, this statement is a true statement, because what is an ordinary damage is the difference between the contracted price, the market price, and the contracted price is a point. A is the right answer. Question number 34. What is it? When contract is divisible and one party has enjoyed the benefit of the part performance, then the other party may sue on the quantum merit. Is it? Yes. Once the other person gets the benefit out of your work and the contract is rescinded, now at least to the work which you have done with which the other person got benefited need to be paid. So that we call it as a quantum merits. And question number 35, when monetary compensation by way of damages may not constitute the adequate remedy for the breach of contract, courts may order specific performance. Is this statement true? Perfectly true, 200% true. A is the right answer. Question number 36, X, a shopkeeper leaves his goods at a Y's place by mistake and Y treats the same as his own and uses it. Y is bound to compensate the X for it under the principles of quantum merit, as much as earned, and nobody can get enriched themselves at the cost of the others as a point. And then friends, question number 37. Dash means an order of court restraining a person from doing what he promised not to do. It is called as injunction. B is the right answer. Question number 38. To file a suit under quantum merit, the original contract must have been discharged by breach of party by non-performance. Yes, original contract must be completed. That is what we have studied in the quantum merit. It's a true statement, friends.